over the thing I'm asking for. And I cannot, as a capital defense attorney, look at my client and say, I trust the government to turn these things over, because every time I show up, it said, we don't have it, you're a liar, Greg. When they do have it, and it gets turned over right after court, when the video cameras and the news cameras go into the ether. I cannot trust from a death penalty lawyer's perspective that these things are happening. And that is why I'm asking for all investigative material to be turned over to this court for an in-camera review to determine what evidence is exculpatory and what evidence is discoverable under both Brady obligations and Rule 7.2. This has gone on for so long that I am at the limit of what I can do. And it's a shame, because I don't walk into other courtrooms and say these things. Wait, okay. And by the way, I heard about the statewide emails. So I can't trust her.
Hey, both of y'all. Stop with the personal attacks. I understand this is a emotionally charged case, and I understand you all are advocating.
It's already on.
Aggressively.
He just told them.
Hey, fellow citizen, thank you. I understand emotions run high and you all are working hard, but these personal attacks back and forth are not really helpful to moving the case down the road.
I agree.
What about just a discovery conference? And if you want the court to moderate it, I will, where you can inventory what you've received with what the Commonwealth has given, so that we're all on the same page, so that you have everything you're entitled to. Would that do as well, or what's?
My preference would be for all investigative material to be provided to the court and for the court to undertake an in-camera review. Now that's doing the worst thing, which is making my work your work.
My question is, I know what you have and don't.
Oh, we can certainly provide that, but well, okay. How about this? I'm willing to start with.
I'm going to get stuff from the Commonwealth, and are we still right back to getting some kind of inventory about you have A, B, C, D, E, and Ms. Fugate gave me A, B, C, D, E. Aren't we still back to that?
We can start there. That would be an acceptable starting place.
If you think there's a better way, here's what I want. When it comes down to the trial of this case, I want you to have all the discovery you're entitled to. You need to have everything from your officers, because they're holding anything and they give it to you late. That's going to be a problem.
I understand that, Judge. They have everything.
Pardon the interruption. It's not just the exclusion of evidence. That's not
Mm-hmm.
panacea.
Mm-hmm.
Okay. If that evidence is exculpatory or could lead to exculpatory evidence,
Mm-hmm.
then that's constitutionally mandated. If I get it 2 weeks before trial, the remedy of just excluding it doesn't do anything. And I am at a point where it's hard for me to accept those statements. So I don't mind to start with a discovery conference.
Well, look, I can order the Commonwealth to turn over everything to me in camera.
Yes.
But what makes you think if she's withholding something, and I'm not saying that she is, but if she is, she could just as easily withhold it for me, right? I mean, I don't know what's out there.
Correct, but what it does is it crystallizes that evidence in time and court record that the court can review. So that in the future, for example, at the end of this hearing, if she turns over more evidence to me that was previously said didn't exist, then the court can say, hold on, I have the sealed file where you told me everything was in there. And now there's this new evidence, which you said didn't exist. And so then the court can make that determination based on freezing the status of that discovery production in time. Now, I don't mind. I think that the court's suggestion on a discovery conference, I think that's a great starting place. And then we can do an inventory there, and we can file an inventory with the court, and it's in the court record. And that might accomplish the same thing, except that what it doesn't do is it doesn't look at, from an independent lens, whether or not the things that she has turned over versus the things that exist are producible, are discoverable. And so without an idea of what she has, then I can't enforce discoverability.
And I appreciate that argument, but if I heard Ms. Fugate, and maybe I misheard, everything, they have everything.
We give them everything. It has always been the same rule, this office, that they get everything, regardless of what it is, regardless of whether it can be used at trial or not. We still give it to them, regardless. If it comes into me, we immediately copy it and send it out.
Your Honor, that's demonstrably false. And the reason that that's demonstrably false is because the evidence, the DNA report that was returned in August of last year was not disclosed to us until after Election Day in November. So they sat on a DNA report showing no male DNA in a case where they've alleged that my client sold her baby for sex.
We never alleged that,
I
Judge,
don't think that's part of the Commonwealth.
ever.
Well, that's where everyone else
Ever.
has
That would be
been.
the public, but not our judge. And for the record, I even showed Ms. Croucher the way that Beast works is they do not, once that lab is complete, they don't send it to us. I wish they did. I wish they did. Instead, we have to go in there and check it. And with as many cases as we have, we cannot go in there every single day, every week, or even every month and say, okay, let's check these.
So in a capital murder case where we request a discovery, it is a total coincidence that the DNA report showing that there's no male DNA was withheld until after Election Day, a
This is what
4-day
we're talking
period.
about, Judge.
This is what I'm
Yes.
talking about.
Making
Well-
false accusations.
I get called a liar every time I walk in here, and I've got the receipts, and I want the court to see them. It's frustrating to do this for 14
It
years.
is frustrating.
To do this for 14 years and to walk in this courtroom and get called a liar by someone who immediately after court turns over the evidence that earlier she said was not existent or proved that I was false.
Call the officer. At any point, he could have called that officer and say, what happened?
We'll follow the court's orders, Your Honor. I've reached the point where I have to do something about this. I can't keep doing this.
You want Commonwealth to turn over everything it has to the court under seal. Is that what you want?
Everything, all investigative material.
All investigative material. Okay. So
That
ordered.
judge.
So
With an
ordered.
inventory of discovery attached to it, it's everything.
So ordered.
Everything.
Court will consider to what extent a discovery conference might be helpful. Do you think it is helpful beyond that, or is that,
I would like a discovery conference, but I can look at my entire file. If there's something in there they don't have, we'll make the copy that day.
We accept those terms.
okay? Where should that discovery conference be? Here in circuit court someday? Is that as good as any?
Yes.
Okay,
May I grab my phone to?
absolutely.
So relying on these technology devices.
What day did you suggest?
I haven't suggested one. You all suggest to me a day, and
What days do you do them? Any day or like,
never done one.
okay.
I've never had to do one before.
Is there a first Friday that you do not have child support? Or even after child support?
Yeah, what about a Friday? Give us a good Friday.
How
So
does September 6th?
what are your all's Fridays like?
They're normally terrible, but because Jessamine, Scott, and Franklin and Fayette all run their motion hours on Fridays, so it's usually a
Well,
fiasco.
that's the day that I don't have anything on a regular basis. So Friday is the day that I try and work in things that aren't typically heard.
Both Ms. Croucher and I are available on the 6th of September, Your Honor, if the Commonwealth is.
Do we have anything on September 6th?
Oh, I just wanted to.
Is this a matter that
On the
can
3rd?
be conducted in chambers?
Yes,
But I have to be in
But-
court.
but
Oh,
he's got, yeah,
About the
she's got
30th.
cases,
How
special.
about the 30th?
Friday.
Yeah, the week before that one.
September the 30th.
Oh, no, sorry, August.
August the 30th.
That's both open on our calendars.
Mm. I'd rather not do August 30th, honestly. I just got a bad vibe about that day.
I feel like there was some reason for August 30th anyways, but I don't remember.
It's just,
And then the 23rd, we have mediations of August, so that won't be an option.
The 27th of August, I have a trial set, Your Honor, in my last week, so I won't be able to do a trial on that day. That's a Tuesday, 27th. So I'm just offering.
you're not gonna be here?
Kentucky.
You're not gonna go out with a bang and?
No, I'll be
Your
here,
last
but
day?
what I have to do is I've got to do a lot of transfer memos on cases,
Uh-huh.
and that's gonna take up, and
I'm
Okay.
do final stuff, that's gonna take up a majority
What
of
else,
the week.
what else do we have on the
It's a
27th?
Tuesday, Judge.
Oh, yeah.
Absolutely. If I had any of those little church fans, I'd distribute them. That's the next thing I'm gonna get.
Got my daughter one with things.
We have what?
How many set on the 27th? I can't do it. August the 27th? I can't do it September
Well,
27th.
October the 4th, the next Friday. Greg and I both have that open.
No,
Or no,
yes, I do. I leave the 5th.
October the
Sorry.
4th?
October 4th?
We can, as long as it's in that, when my son's birthday is the weekend, and
Okay.
I'm taking him out. So
Okay.
that's fine.
Should there be no problem getting this done in the morning?
No,
It won't take
not for us, not for me.
I think we can do it in 2 hours.
a couple hours? Okay,
That'd be
as
great.
long as you can be down here at 9 o'clock.
Stay at the state park again.
They have child support on the 4th? Well, we'll just bump child support, just tell child support we'll bump it until after this. How about that? Is that okay?
That's fine on that. I don't live
Okay.
You tell me when.
I think, just text, yeah, we'll just move child support. They'll just have to wait an hour and a half.
So at 9 o'clock on the 4th?
Yes.
How mad would you all be if we did 10 o'clock?
Well,
And leave at 7 a.m. rather than 6, or
And that would
Miss-
work,
Miss-
because you could do child support at 9,
Okay.
normally it doesn't take an
Okay.
hour.
if that's okay, if
And I
that's
would
gonna,
still get out by 3.
okay, we could do it at 10.
They would just let me stay at home.
10 o'clock. Mm-hmm. Discovery Conference, yes.
And we can waive Ms. Lawson's appearance on that. That sounds like
Yes.
something we can do
I
in
would-
chambers.
Yeah, there's no point in having her here for that.
Thank you. And will the officer be able to bring the entire investigative file at that time?
It's a pain in the neck.
I don't know, but subpoena is necessary in this. Well, that's the company's. We just want to make sure that the entire investigative file is available to the court.
If you'd have the officer here that day, that'd be great. Right, anything else on discovery?
I think we've got that squared later on.
Okay,
Motion.
Oh, yes.
Judge, we filed a motion for an adversary bond hearing.
okay.
We're entitled to one under the rules and we've not requested one before. So we're asking for an evidentiary to be scheduled and we're looking at probably November. And I imagine that would be a full day, possibly bleed into a second day of testimony.
I'm entitled to that, Your Honor. I was just gonna ask for a hearing.
Okay. 2 days for a bond hearing?
So I don't know what the Commonwealth would present, but we would have at least 2 expert witnesses who will testify, possibly additional lay witnesses. That will testify, will be significant medical evidence that the court will hear at a bond hearing. So I think from the defense, we'd anticipate several hours to present our side of the hearing. And I don't know what they would present. But at least for us, it'd be significant testimony. We think we can cram it into a day, Judge, if we can try.
Well, if it takes 2,
I'm just warning the court,
I
there'll
don't,
be, medical testimony as that.
okay. Anything in November?
Why does the village have invited you to they just walk off on Thursday? It's, you know what I'm saying?
So I'm trying to murder games, 3 days a week from nothing. In December.
What days does the defense have in November?
So I have the weirdest murder trial schedule ever because we're trying a murder for the month November, 3 days a week. Which is frustrating. Please don't. It's so terrible. Because it's going to be a whole month of a murder trial, but it should be 2 weeks of murder trial. So the judge there has taken off every Thursday and Friday. So it sounds like Fridays are good for the court here.
Mm-hmm.
So truly, I think probably go 15th. Let's see, when is Thanksgiving? Is it the?
Very last weekend.
It's late.
Something like that.
Okay,
I
so
can
maybe the
do-
22nd?
I've got a 2-day trial that's gonna end on that day.
Okay.
I could do the 15.
I think we have arraignments on the 15th, and then the week after we have mediations. Because I think that has 5 Fridays in it.
With December 6th, you got?
That is December 6th.
Unless you have child.
December 6th?
Yes, sir.
That'd be a Friday. How does December 6th look? What about the 5th, the Thursday?
We have jury trial set, but
The following-
Doing the murder case here at home. They're still doing the murder case back at home. I'm just waiting for them to call my name.
Mr. Hey, Ronnie Quentin,
Yes, sir.
you need to mute.
Okay.
Thank you.
Do the 8th.
Yeah, we need to make sure we've got reports.
So what day are we talking about?
November 8th.
I want to get that murder of the 4th and the 5th.
Judge, if that's the second Friday in November,
Yeah.
that would be settlement conference day.
Okay.
Have we said anything about that?
We have not, so we can block
Let's
it off.
do it. Let's set the settlement conferences on another Friday then. And you think you can do this in a day? I realize I look askance at a day and a half bond hearing but I don't want to, if you think it'll take a day and a half, we'll take a day and a half.
Is there any Thursday that Ron has cases that will obviously not be good? And if so, we can start on Thursday.
I'm sure there are.
Or
I just
one of
don't know.
our-
I don't know which ones they are right now.
Availability.
That's
I
right.
think it's self-service in here.
But there's one more thing that I need to check because got a witness who's testifying in New Orleans that first week. She sent me her schedule.
So she's not available today. We might have to go into.
And she's not available, somebody not the head. Welcome to the thing. Okay, well, that's fine. So later in November.
I don't know if
20, oh no, look at Ron.
November 21st, I don't know if Ron has Robert Vaughn and Ron,
I don't have,
Josh Holden.
don't have that one either.
And between murder trial right here, 21st, 22nd.
No, like 14, 15.
I can make it work.
There's nothing to say that
We just may need to continue seeing your cases.
We have 3 trials on that
Maybe the
7th.
14th and 15th. What about the 14th and 15th?
We have Mary Ellen Johnson and Greg Burnett.
Cornett, I know that name.
I know who.
I've had him in Laurel County.
No, I mean,
Well,
standing
I don't know, I'm about ready to decide that, you're not entitled to a bond hearing, I guess. It doesn't look like you're
What do these Saturdays look like? Okay, so I could do, so 14th and 15th, you got jury trials. The 21st and the 22nd, what was our conflict there?
I have a trial, but it's a juvenile murder case, so I could probably bump it because there's no jury coming in.
Okay,
How
let's,
does that look, 21st, 22nd of November?
21st is when we have the Vaughn and Holden cases. Is Josh Holden represented by the attorney from Lexington? 21st November. If so, then it will go.
the 22nd would be better for me, by the way. I don't know if that was something else.
So you're out the 22nd. They can cram it in that one day. That's a Friday. Well, that technically means that's our mediation day, but we can move that.
22nd of November.
I said that.
Okay. Adversarial bond hearing, 22nd of November.
9 a.m., Judge.
That'll start at 9.
Judge will tender a transport order for Ms. Lawson be brought here for that.
Yes.
Judge, I would just request an expert disclosure. I know by the rule I have to provide it in writing. I would be doing that.
Okay.
So that way it's in the record.
We're working as best as we can on our experts. There's obviously a lot of material to move through, but yes, we would like to have an expert disclosure well ahead of that day.
Okay.
And we can file that in the court file.
Okay.
Okay.
The 2703 motion. So
So I think that concludes the motion for bond hearing.
Okay.
We have one more.
okay, so Your Honor, the last time we were in court, we indicated that, or we set a date for the petition to change venue.
Mm-hmm.
Commonwealth attorney indicated that all these people were coming out of the woodwork saying that they didn't sign this stuff, they signed other stuff, or it's not their signature at all.
Mm-hmm.
The court said that she was getting phone calls, I'm sorry, the Commonwealth indicated she was getting phone calls about it.
Mhm.
We learned later that she was reaching out to witnesses. I'd like to present, proof of that to the court now, if that's okay.
Yes, you may.
Thank you.
Judge, that's gonna be a Facebook message for
Mhm.
mine, and I'm going to object because technically it's work product. If I can have a chance to respond to that motion, Your Honor, or if they call it a notice of intent, whichever they do, I can have that filed this week. The AG's office has actually reached out to me on that. And then you can decide whether they can or whatever prior to that hearing.
Judge, I'm pulling it up right now. Would you like to respond, please?
Well, so what's your motion?
My motion is to receive the Facebook messages of the Commonwealth attorney, leaning on witnesses in this case.
Well,
Because I see from, again, she stated that people were reaching out to her, and it's actually her reaching out to witnesses.
so Mr. Colson, is there anything wrong with the Commonwealth attorney reaching out to your affiance?
No, but if she is leaning on them in order to get them to recant, then that's a problem.
And I'm not, Your Honor, and they will be present to testify, and he can go through that completely with them.
I just don't,
I'm the Commonwealth's attorney, and I am needing to speak to you about an affidavit you
Mhm.
signed in the Erica Lawson case.
Mhm.
And then I have proof of her harassing other people via
Judge,
Facebook
that's not
message.
Okay, so-
harassment. That's me doing my job as Commonwealth.
And so what we have is a
Judge, I'm going to
Okay.
object. That's something completely separate from this, completely separate. And that's his whole purpose of introducing that.
No, the purpose is to show that the Commonwealth
No.
attorney gets on
okay,
Facebook.
stop.
And explain it to you.
Mr. Colson. It's your contention, as I understand it, that your clients, in support of the change of venue, are not contacting the Commonwealth. Instead, she's contacting them. Is that right?
There's a second part to that.
And I think you're saying, or you either believe or you suspect that she's leaning on these people. Is that right?
With a second part, yes, sir.
Okay, so can you not just contact these people, have your private investigator contact those people yourselves and find out, rather than going through the route of getting the Commonwealth's information?
I can't in this circumstance, okay? First, the rules of professional conduct require that a attorney not make themselves a witness into the litigation, okay? Which is why we send an investigator who's not affiliated with our team in order to get these affidavits. Second, the allegation has been made that we have done something wrong, again, because it's always accuse the defense, right? That we have done something wrong here, that the investigator who got these affidavits didn't actually talk to these people, didn't get their signature, hoodooed them on what they were signing, that sort of thing.
Mm-hmm.
And so for us to go back now and say, oh, hey, make sure your story, what's your story here? Did you do this right? Did you do that right? And then when we come back to court, the Commonwealth attorney is going to accuse us of solidifying these people's answers and saying that we've gotten them to say or do something that isn't true. So now I'm in a position where I can't send an investigator to talk to these people because it's going to look like I'm trying to get them to double down on something. It's going to be more input from my side of the aisle, where she's going to get up here and tell the court that we're doing things that are unethical or illegal.
But how is getting her phone or Facebook records going to change that?
Because I think that it's likely that's going to show that she has pressured people into saying these things.
Judge,
That's what I
Well, I
suspect.
mean, I just tell you, I don't see anything
each of those
very pressuring
witnesses,
in the one you attached.
Yes.
That seems kind of a generic. A lawyer reaching out to a witness, hey, I want to talk to you about this case. Will you call me? And you have an investigator. So, lawyers that have investigators might do that. But the fact is, lawyers do it themselves all the time, right?
The lawyer doesn't make themselves a witness to it because they may talk to a witness, right? But then they have to get an affidavit or a recording or something that's admissible Because then if that witness backs up on what they said before, then that lawyer's in that predicament where like, oh my gosh, they've made a prior inconsistent statement, it's admissible under 803, and I know it because they made it to me. And so now I'm a witness in this case where I'm supposed to be an advocate. And so the Commonwealth has the ability to use investigators, including
True,
city
but there's
police.
there's nothing wrong with the initial reaching out, right? I mean, you
You
wouldn't,
can schedule interviews, yes.
you wouldn't send your investigator out to talk to a witness. If you call up a witness and the witness says, I don't know anything about it, I wasn't there, whatever, you're not gonna bother sending an investigator out, right? Don't you have to make the initial call to kind of see, well, this guy might be helpful or not helpful?
I don't truly, because then I've put myself in a position where that person tells me, oh yeah, it's a total lie and I've got video of someone else doing this shooting and I can't wait to show it to you, right? It's cleaner and better to send an investigator to collect that information. That way the role of collector of evidence and advocate are kept
What
separate.
if you don't have the luxury of an investigator? I mean, I'm just,
Again, the Commonwealth has that same luxury. They have city police, the sheriff's office, KSP, and now the FBI is investigating this case. Even in private practice, I hire investigators. In fact, the same people that I hire in this case.
you don't think a police officer or law enforcement might be more intimidating than the Commonwealth's attorney?
I don't know, Your Honor, but I would like to know what she's saying to these people in order to get them to make this statement.
Judge, they'll be present. He can ask them, they will be present.
So you want time to respond.
Yes, and attach applicable case law, Your Honor, I can do it by the end of the week. We don't have any trials tomorrow that I know of.
There are no trials tomorrow.
Okay, I can have it hopefully tomorrow by the end of the week regardless. And then I
Okay.
can reply to it.
Okay, court will give the Commonwealth to the end of the week to file a response to this motion. What is it specifically you want?
I would like messages between the attorney and the applicants.
I would like to, Judge, I already have witnesses subpoenaed. I prefer not to have someone track them down or me to serve them again. And if the court can make a ruling prior to it on those issues.
The problem is, and I hear what the court's saying, the problem is that if the court does enter an order narrowly tailored to those witnesses, then under the Stored Communications Act, the common carrier is going to have time